for Policy and External Affairs at the NYU McSilver Institute. I'm part of the MCTAC and CTAC teams, the Managed Care Technical Assistance Center and the Community Technical Assistance Center. I'm joined here by Adam Falcone, who many, if not all of you, are familiar with now, based on the in-person, web-based, and now this workshop series assistance that he's provided around managed care contracting. So thanks again for indulging us with giving your fellow participants a few extra minutes to jump in and join us. We're going to get right into the content today. So just there isn't going to be too much of an overview or a window of folks to just get things started. So folks are familiar with the previous in-person contracting sessions that were offered and the web-based offerings and resources, including the plan perspective, the provider perspective. Two things we did want to mention. 3 weeks ago, the summer's going by so quickly, MCTAC released its managed care plan matrix. So we have 8 of the 10 plans that will be active in New York City when the adult system officially transitions to Medicaid managed care October 1st. We have their contact information for specific people to talk to for specific types of inquiries, as opposed to just calling an 800 number. And then we also have some of the specific contracting provisions and standard language captured there as well. So we strongly recommend folks to take a look at that and use that as a resource. For the folks who aren't in New York City, we'll be expanding that to encompass all of New York State, and then also when we get closer to the children's system transitioning to reflect the whole system transitioning to Medicaid managed care. Also just wanted to let folks know, Adam has generously agreed and offered to continue working with us to take some of the content that we've been presenting in various formats and to develop the contracting cheat sheets, as we'll call them, or like one-page fact sheets with the very high-level takeaways. I know many people will be excited to be able to tape it up on the wall and just be able to refer back to, and it'll really overview and introduce some of the concepts that Adam has been working through with us over the past, wow, it must have been 8 or 9 months now. So we're coming full circle with some additional materials in addition to the recordings and the slides and this workshop series for folks to refer back to. So thanks again to Adam for helping pull those together. Again, just a quick reminder of where we've come so far. Adam did a presentation on the anatomy of a contract and a review of the team-based assignment back in mid-June. 6 weeks goes by quickly, folks, am I right? We offered an office hour so folks could come and bring questions regarding the assignment and contracting in general. We gave folks until Monday, July 20th to submit using the online survey link, just the provisions that they found problematic or that they wanted to comment upon. We were thrilled to receive close to 80 submissions. So I think it's reflective of both just how useful the content that Adam's presenting is, as well as how great of a need there is for assistance or supplemental resources in this area. And then here we are today, July 29th, 9:30 a.m. with a wrap-up and assignment review. So without further ado, I just wanted to jump in and give folks a little bit of context on who the workshop participants were. So when we're identifying with Adam some of the provisions and some of the comments, it gives you a sense for the sample and who this is coming from. So in terms of agency licensure, roughly half of the participants that submitted the response to the exercise are licensed by OMH, about 25% or a quarter by OASAS, closer to 10% OCFS, and then we've had a nice chunk that was other. And again, folks are coming from all the parts of the state. New York City is a little bit closer to the official transition date for adults, but we're very encouraged to see that folks from outside of New York City, upstate, Long Island, are also engaging with these activities on the relatively earlier side, although before we know it, the managed care transition for rest of state will be upon us as well. And then again, for the most part, most of the participants serve both adults and kids. and then a smaller percentage serve exclusively adults. And very, very few of the folks who participated in this workshop offering serve exclusively kids. But again, as the kids system is looking to transition in 2017, it's a little further out. And again, we'll be absolutely offering kids provider-specific resources around contracting as that approaches and we get more into 2016. Also interestingly, of the folks who submitted responses, roughly almost 70% already have a contract in place with one or more MCO, and just under a third do not. And so assuming that the NYC folks are bringing that number up, but you know, it goes without saying that whether you have a contract in place or not, there's never a bad time to consider your contracting strategies around Medicaid managed care. Also, home and community-based services, the designation process for New York City wrapped up at the end of last year. There are roughly 170 designated HCBS providers in New York City, and the rest of state HCBS designation application process is currently open. So if folks are interested in learning more, there's information on the website available, both at MCTAC.org and then also via the New York State's website on home and community-based services. So of the participants, just over 70% are already designated or planning to apply for designation to provide home and community-based services. And then we were very interested by the responses that we received around this, just in terms, because of the wide variety and range of responses we received. So the question here is, who at your agency reviews and approves contracts? And so the answers that we supplied were the CEO, the CFO, the board, a legal department, a chief program officer, and then others. And others was remarkably high. So we obviously we didn't list out every possible position. But so we just wanted to spend a minute and kind of go through who, you know, at respective agencies, you know, tend to have a hand in the formal contracting process. So a large number of folks said it was on the admin side, you know, or Medicaid regulatory specialists, the billing team, you know, other staff who tend to assist the CFO. In addition to CEO and CFO, the chief operating officer or chief administrative officer, if your agency has those positions. We had a scattering of vice presidents and senior vice presidents, executive, deputy, program, and assistant directors of a variety of different divisions and job descriptions, including community services, operations, finance, sometimes clinic managers and program managers. We had a revenue cycle management manager who takes a look at these. A couple of agencies reported that the pastor at their organization has sign-off or takes the time to review these. And then also something that Adams addressed previously, a number of agencies also mentioned that they had outside counsel or internally taking a look at these different contracts that are moving through with the managed care organizations. And so again, Adams, you know, if you're interested in learning more about this, we can come back around to it at the end of the presentation. But just generally speaking, you know, it's one of those things it's a nice luxury to have, and that, you know, Adams talked about, you know, kind of like a cost-benefit analysis based on the contract and what you might be trying to work through, you know, running it through an outside counsel in terms of, you know, the contracting process. So I think folks by this point are pretty familiar with Adam. So I'll turn things over to him at this point, and just if he'd like to say a few words just about his experience to refresh folks' memory, that would be great. And again, just wanted to thank him so much for all of his work on this. And Adam, I will pass the ball to you.
Great. Thank you, Dan, and good morning, everybody, and welcome to this final, I guess, installment of this series for the assignment review. I want to thank everybody for your level of engagement. I think it's been amazing, and it shows your commitment to your agencies and wanting to protect your agencies from poor contracts or unfavorable contracts, and I think that shows a lot of commitment, and that's great. So thank you for reviewing the sample contract. Today on the webinar, I'm going to go through different provisions that I felt were the most important provisions, describe what I would say the issues are, and what issues were commented on by you. If you're listening to this, I would encourage you to almost use a checklist approach, listen for what I say and compare that to the comments that you made and sort of check them off to make sure that you caught all the ones that I mentioned on the webinar today, and sort of highlight those that you didn't catch. I'm also going to try to comment from time to time on whether I think there's a good chance or a likelihood of you being able to have the provision changed or negotiate a change in the provision, and if you were able to negotiate a change, what you might want to look for. If there's a provision or a recommended change by one of the participants in the webinar that I saw where I feel there's not a chance at all in getting something changed, I'll mention that specifically. I also wanted to remind everybody that the sample contract that you reviewed really is the worst of the worst. I have basically amalgamated all the disfavorable contract provisions in a single place. I would not expect that you receive a contract from any MCO that has this many problems in it. This is just merely for purposes of illustration. You may see a few of these things, but not necessarily all of these things in a single contract. I'll try to leave time at the end of the webinar today to answer any questions, or if I didn't mention your comment and you want to raise it at that point, feel free. But why don't we dive in and see how we all did. The first provision, this is from the definition section, section 1.1, defining a clean claim. Many of you, if not most of you, raised questions on the lack of sort of the vagueness of this provision, wanting for a further definition of what it meant for a particular circumstance requiring special handling. What does that mean? One of you said, as a billing specialist, it's always been helpful for insurances to be clear on what their expectations are when it comes to submitting clean claims. What is the format, diagnosis code, procedure code that's required? Generally, what I would say here is that this is a very common provision for how it's written. It is often written this vague, and you have to go to the provider manual typically to figure out what kind of claim form to use, what codes are allowable, what kind of documentation, what kind of prior authorization is required. You will probably not be able to have that level of detail inserted in the definition section for what a clean claim is. That said, New York law does have a prompt pay law, and that's where this clean claim definition really emanates from. One of the purposes of defining what a clean claim is it determines when the clock starts running on how long the plan has to pay you. So once you have a clean claim, then the clock starts running for the plan to pay you within that specified time frame. And off the top of my head, I think it's a 30-day requirement under New York state law. And so if you want to check to make sure the clean claim definition is defined at least consistent with New York state law, you should take a look at the prompt pay law and make sure that the definition of clean claim in the state law matches the clean claim definition in your contract. A second concern that many of you raised was that if a practitioner is under investigation, you should still get paid until the investigation is over, and then if necessary, pay it back. I completely agree with the theory there that you should be paid if nothing's been determined yet for certain. However, plans don't have confidence that you have money to pay back. In those situations, they may not want to, for their own cash flow purposes, pay out money they don't need to. And so it's very common that if there's any question on whether the claim can be paid, even if it's because a practitioner has been under investigation, those claims are going to be pended and be on hold until that issue is resolved. The same is really true in a coordination of benefits case where a patient has multiple insurances. Typically the claim will be put on hold and be pending, and the clock doesn't start running. So recognize that that essentially any investigation can cost you as well in getting in the fact that claims won't be paid. One of you had a question on what it meant in the third sentence about the term shall not include. So this is a definitions section provision, and therefore when it refers to term, it's talking about the term of clean claim. One of you mentioned the concern, or some of you mentioned the concern about what does it mean by setting forth applicable federal and state law and regulations. I'm actually not aware of any federal law that defines what a clean claim is. It's really defined under state law, and it's perfectly acceptable if you want state law to be rewritten as New York state law. That's perfectly fine. I don't think a plan would fight you on that. And then one last comment on those of you who just sort of bemoan the lack of detail on this section. In addition to the provider manual, I think it's perfectly reasonable for you to request the plans to provide specific training on how they want claims submitted. And I do think that there's going to be some trainings coming up during this transition. That's definitely helpful to get the plan's point of view about how they want claims submitted, any specific requirements. If you have questions, that's your opportunity to ask them. This next section was also a provision from the definition section, covered services. Many of you, if not all of you, indicated that you should have a specific list of what services are covered so that you're clear about whether a plan covers maybe a service of yours or it doesn't. Also wanting to ensure if there's any limitations on those services that you would find out what those are, because that won't be found in the contract itself. That would be dependent on the particular product. So Medicaid, you know what's covered under Medicaid, but if it's a privately insurance product, you don't know necessarily whether it includes ACT or PROS or some of the specific services that you may or may not provide, and you want to make sure that that's included. Based on some of your comments, I think there was a little bit of confusion out there between the definition of covered services and scope of services, because some of you were concerned that you'd be agreeing to provide services that you don't offer, which is a valid concern. Remember that covered services is what's covered under the applicable benefit package of a particular product, like Medicaid versus Medicare versus commercial insurance, while scope of services is what you're committing and agreeing to provide to the members, to the enrollees of the health plan. Some of you also wanted the phrase medically necessary to be eliminated. That's not really likely to happen, and that term is defined in the next section anyways under 1.5, which we'll talk about in a moment. It's also defined in the Medicaid RFP or RFQ, and it should be consistent with that definition. It's perfectly acceptable to have covered services limited to those that are medically necessary, and we'll get to that now. So 1.5, the definition of medically necessary. Many of you were concerned that it's the plan's discretion on whether a service is medically necessary and not your own or not an independent party. It is industry standard that the plan gets to define what medically necessary means. However, in the Medicaid context, as many of you know from my prior webinars, the plans must follow the guidelines that are issued by OESAS and OMH, the locator tool, and the other tools that the department currently uses for determining medical necessity. So there are some safeguards sort of built in. Some of you may want that language to be specifically added and reference the tools or the policies of OMH or ESAS. You could ask for that language to be included here. However, if it is a commercial contract or a commercial product, you know, those tools don't apply to non-Medicaid products. So the plan may not want this provision altered specifically to apply to all the products that they might offer. Some of you wanted this definition to include preventative services, not just treatment or diagnosis. Seems like a fair comment and something that you might want to include if you provide services that you think are preventative. Some of you were concerned that there was a reference to hospital services in this definition, that it was only covering or applying to medical or hospital services. I don't think you need to remove the reference to hospital services, even if you don't provide hospital services. This is just a broad standard definition, and if you don't provide hospital services, then it's really not relevant. But I do think the concern is well put for those of you that were concerned that behavioral health doesn't fall into the definition, or may not fall into the definition of what a medical service is. I think that many of us do view behavioral health as part of medical services, but if you're concerned that the way the contract is written or the definition of medical services would not include behavioral health, I think it's reasonable to ask that term be clarified so that you are certain that it includes those services. Or you may want it to replace the term medical service. The next section, section 1.11, refers to the provider manual, and fortunately many of you did catch, I think, what is the most glaring problem in this provision, which is the plan is allowed to change the provider manual without advance notice to the provider. That should be completely unacceptable. You should raise the question with the plan, if they don't provide notice of the change, how are you supposed to comply with that change in the provider manual? Obviously you can't. So you want that language without notice struck from the agreement. Now some of you asked that you receive a notice, and that if you don't agree to the change, you should be able to object and in some cases terminate the contract. That's unlikely to be a change that you can win from the plan as a concession. And the reason is because the plan isn't going to want their own internal policies and procedures, even if they affect you, to be at the mercy of the providers that participate in the plan. Think about it from their perspective. If you have internal policies and procedures, do you really want to give somebody else the opportunity to say whether you can change your own policies and procedures? Probably not. And so generally, plans can change their policies and procedures, their procedures, without your approval. Even if you object to them, don't like them, you're bound to them. Now, you may be able to win a provision that says if they change in some way, you have a right to terminate the contract, and I think that's reasonable to ask for. So you're not opting out of their policies, but you're invoking your contract termination rights. But it's not likely that you can actually disapprove their proposed provider manual changes. Make sure you distinguish here between contract changes and changes to the provider manual. As I said before, they should be able to change their provider manual as they wish, just providing notice to you. That's different than changes in the actual underlying contract agreement. They should not have the right to change the contract and amend the contract terms without your agreement. And if you don't agree to those terms, as we'll see later in the termination clause, the contract should remain as is if you don't agree to their proposed changes. One of you made the very insightful comment that many times the manual, the addendums, the agreements, they may all say different things on the same topics, and it's confusing about which apply. You'll see in many contracts there's language that says if there's any conflict between the plan's contract and the plan's provider manual, the contract supersedes the provider manual. If you're missing that clarification in the contract, you should request it, because the plan's contract should always overrule anything that's said in the provider manual currently, or changes later on and changes to the provider manual. You always want the contract to govern. Some of you asked how you might access the provider manual. This is something you should certainly ask the plan for before you sign the contract. Most plans will make their provider manuals available online and available for you to review in detail if you want to look at certain types of areas such as credentialing or payment or billing. They should be available. There's a few startup plans or FIDA plans perhaps that are new. They may not even have a provider manual yet, or it may only be in draft. And certainly I can see that being a problem. It may not be a make or break issue for you, but it should indicate to you that there may be some growing pains in that particular plan. There may be some operational challenges as they get afoot. Moving next into the next section after definitions, section 2.1, this is the scope of services section. So as I mentioned, this is what you're agreeing to provide to the enrollees of the plan. Most of you identified that the major issue here was there's a all products clause that is nested inside this provision, in which it says that you shall participate in all the plan's products that the provider is qualified to provide services under. You should try to remove any all products language from your provisions, and hopefully the final RFQ and the final contracts that are signed with the plan will prohibit Medicaid plans from inserting all products clauses in their agreements with providers. Some of you wanted clarification about whether certain services you provide are within the plans, are within the scope of services, and you wanted opt-out rights. For example, some of you might provide the PROS services, but even though it's a covered service under the plan's reimbursement rate may not be sufficient to cover your costs. In that case, you might want the right to opt out in certain services. Even if they're covered services, you may not want them to be under your scope of services where you're obligating yourself to provide them because the reimbursement for that particular service is not sufficient. So this is why it's very important to know exactly what is included in your scope of services, what the payment rates are for each of those services by the plan, and if there are services there that are not being adequately compensated, this is where you would want them to be excluded from your scope of services. Recently, one of the plans wanted to be able to add new products, and were insisting upon that in their contracts, and we struck an agreement, sort of a compromise, in which they could add additional products so long as the reimbursement rates offered by those future products were no lower than the current reimbursement rates under the existing products to the provider. And that way it was protecting the provider from an all products clause that added additional products that had lower reimbursement rates. It would have prohibited that, or at least required the plans to get the provider's consent. But if the rates were at least the same or more, then the provider didn't have to consent to the new product being added to the plan's array of products, and the provider was comfortable with that language. Section 2.2, the access to services provision. Many of you questioned this provision that required you to provide services on a 24/7-day-a-week basis, since you're not in an emergency room typically and can't do that. I think that this provision, the intention of this provision probably by the plan was to make sure that if a patient needed emergency services, you would refer them out to emergency care if that was needed after hours or on the weekend. But I agree with you that this contract provision suggests that you are a 24/7 operation, and you want the language to be clarified that you don't directly have to provide the services. You can arrange or refer the patient out to an emergency provider as needed. Many of you raised questions about what's this eligibility list that's mentioned here, because many of you check or verify enrollment through a plan's website. So this eligibility list language you might want struck. Some of you questioned whether it's common to have waiting times that are so specific in the provision itself. You do see this sometimes, particularly in Medicaid plans, where the state has very specific access standards with the plan. The plan then puts those access standards directly in their contracts with providers. But if you can't meet those standards, or if you think you can't meet them all the time at least, then you may want to try to get that language somewhat modified, maybe have it qualified that you'll make all reasonable efforts to ensure that the patient receives their appointment within 30 minutes. Some of you did ask, when does the clock start running? Is it based on the appointment time or when the patient shows up? Which I certainly think is a fair question to ask the plan. There was also this very strange language in this particular provision where you had to get the medical directors of the plan to approve any non-participating physician to provide a service or as a covering physician. That seems far too onerous to go to the medical director of the plan every time and get approval, especially particularly if a physician is simply covering for one of your practitioners. And then the second very strange responsibility is the last sentence of this provision, where you're actually responsible for compensating compensating physicians and non-participating provisions. You certainly should try to get that provision struck where you don't have any payment responsibilities to these other physicians. The plan should have those payment responsibilities, not you. Section 2.4 regarding outreach services. The first point many of you raised was this is unrealistic because it would be too costly. Others of you suggested, second, what does affirmative outreach actually mean? Does it mean calling a patient, emailing a patient, providing a home visit? It needs to be further clarified in this provision. I think both of those comments are right in the sense that this is a pretty vague provision, and depending on how the plan defines it, it could be overwhelmingly costly. You may want to seek a change to this provision so that it requires you to make all reasonable outreach, and then you get to sort of decide what is reasonable under the particular circumstances. Some of you said this isn't applicable to you because of the kind of services you provide. If that's the case, then you may want to just get this provision deleted and struck entirely from the contract. But certainly it's not clear what the plan means by affirmative outreach, and if it is costly, then you should raise that to the plan and tell the plan what that would actually mean if you had to provide that kind of outreach every time a patient missed their appointment. Section 2.5 on excluded services. Let me start with a comment that was sort of made later by some, which is, I don't know what this means. Many of you said, I don't understand what this section is trying to accomplish. That is a fair point to make to the plan. If you read a provision, and after reading it and reading it and reading it, you have no idea what they are trying to get at, then ask the plan's rep what this provision is intending to accomplish, what it means. Because I agree with you. If you come into this contract and are completely new to managed care contracting, you may have no idea what this provision actually means. Now, what does it mean? Many plans have a single contract with certain types of providers for services so that they can negotiate a discounted rate. So many plans, for example, have a discounted or a single lab provider, a lab services vendor like Quest or LabCorp, and they have a negotiated rate with just that one single company, meaning that if you are a provider that also has an in-house lab or have some other lab like a hospital lab which you use routinely, this plan's contract won't let you refer to that other lab because the plan wants you to use their own negotiated contracted lab provider, and therefore this would be an excluded service. The problem, of course, in this provision is that you don't know from it what's excluded. You don't know from this provision which contracts the plan may have with a single provider. So it's fair to ask them, what currently are your excluded services that would not be covered under this agreement, so that you can be sure to know that that would be carved out from the service you provide. But this actually won't be, I imagine in most cases, won't be applicable to many of you because many of you don't have an in-house lab where it's a single, where the plan is saying something is excluded, and so it wouldn't be relevant to your negotiations. Section 2.6 relates to referral services. This is also an unusual provision, but a real provision. It has this very strange language that says that you are responsible for the care delivered by providers to whom you refer to. That's a problematic provision. You shouldn't have any responsibilities for the level of care, for malpractice, for anything in regard to any liabilities related to referral providers. You do want to try to get that language struck. In fact, that might even be a make or break issue because there's just no way for you to actually oversee care by a referral provider. In the same way, there's a requirement at the end of this provision that you evaluate the outcome of the referral services and coordinate with the members' care and for the medical needs. That too may be impossible for you to do because you may not have the ability to evaluate the outcome of that referral provider services, or even find out what their services are. And if you don't have the capacity to do it, certainly that's language that you should have struck from the agreement. Finally, some of you mentioned that the requirement in this provision that you have evidence of referral sent to the UM department is unnecessary and would be costly and burdensome, that information or the evidence of the referrals would be available in the patient's chart and available by review of the plan at any time upon their request, but you shouldn't have to submit that information to the plan's utilization management department or immediately by faxing it or any other way every time you make a referral. Section 3.1 is compensation, very important. Here, many of you saw that the plan under this term had the ability to amend the product amendment at any time, because it says plan may, in sole discretion, amend the product addendum. That means that if the product addendum specifically identifies your reimbursement rates and they have the ability to change them at any time, then it means that they have now lower reimbursement rates without your ability to fight that. If it means adding additional products to the plan, to your contract through amending the product addendum, that could be bad too if some of those products have lower reimbursement rates. So you should try to have this language struck so that it's not the plan's sole discretion to amend the product addendum. Many of you also saw that there was a second all products clause in this agreement. There's actually 3 in total. This is the second of 3 of them, where it says providers shall participate in additional products offered by plan. For the same reasons I mentioned before, you should have this all products clause language deleted from the contract or removed from the contract. Many of you might be maybe surprised that there's duplicative language in these provider agreements. Don't be surprised. Many times language is repeated or terms are repeated in different parts of the contract. You may see one repeated one time in the compensation provision here, then you may see it again in the product addendums or in an exhibit. And so if you have an issue with an all products clause, you want to be absolutely sure that you are changing that language everywhere it might appear, because it may not just be in one particular location. Some of you requested that you should have the ability to propose amendments. I'll come to that later in the amendments clause and talk about that. Some of you suggested that you should have a time frame of a year to renegotiate. I'll get to that part later as well. Payment terms, section 3.3. Some of you wanted the definition of applicable state or federal law to be defined further. You could try to get that changed so that it referenced specifically New York state law in regard to payment requirements. Here you may even want it to include the RFQ that New York State establishes or the model contract and have that specifically referenced in your payment terms. Many of you realized that New York's prompt payment law does apply and that there's an interest provision under the prompt payment law, and you may want that language specifically incorporated, if not by reference, actually specifically mentioned and repeated here so that if you have a contract or a claims dispute, you can point to the contract itself and say that you're entitled to interest for any late payments. Many of you saw that the plans must deny payment to you if you don't submit the payments on time, because the language is mandatory. Plans shall deny payment on claims. As I mentioned and some of you picked up on, you should try to get that provision changed so it's discretionary, allowing the plan the ability to deny payment on late claims, but not mandating them to do so, so that you have a little bit of wiggle room in the case you have a claims mishap or a snafu with your billing software system. You can at least raise the question with the plans and try to persuade them to pay on those claims anyways, even though that they were submitted late. The next issue was recouping overpayments by offset. I mentioned many times that offset masks plan recoupments because you don't often know that the plan is recouping payments from you. Ideally, you would want to remove the offset provision, but many plans will not agree to removing that offset language. Instead, you have to focus on ensuring that you receive adequate notice of a plan's determination that there was an overpayment prior to the offset. And many of you recognized that you should be able to get that notice. Some of you realized or requested that you should be paid regardless of whether there's a retroactive disenrollment or of a patient. I have raised that issue many times with plans because it seems unfair when the plans retroactively disenroll an enrollee and you've already provided the service, and then the plan takes some money back. That basically puts the risk on you, on plans or the state's eligibility decisions, which doesn't seem quite fair because once you've provided the service, you can't take it back from the patient. However, it's very difficult to win a change to that provision, except in the states where the state actually allows a plan to keep their capitation payments in the event of a retroactive disenrollment, at least the part of the capitation payment that included any payments they already made to providers. In those states, then you have a good argument to make to the plans that you should be able to keep the payments that you receive from the plan. So on the notice clause, you should make sure this provision provides you adequate notice of a potential overpayment prior to the plan offsetting it, and the ability to appeal that determination if you disagree with the plan's determination that there was an overpayment. Many of you also mentioned the New York State prompt payment law again, and wanting to have that specifically referenced in this agreement, and that is a good idea. Section 3.4 is an unusual provision, but one that I've started to see crop up in plans contracts. This allows a plan to suspend payments to you if they have their payments suspended or delayed by the state. It also allows plans to pass on reductions to you. So if they, for example, during sequestration, when Medicare plans had their payments reduced by 2%, many of those plans wanted to reduce their payments to providers by 2% to be consistent. However, their contracts didn't allow them to do so. And so now you start seeing provisions appear in contracts allowing the plans to reduce payments to providers if they receive a reduction in payment. Many of you made the very astute recommendation that this provision be struck, and that you shouldn't have your payments reduced or suspended, even if the plan gets their payments reduced or suspended. Many of you believed and made a good argument that it shouldn't matter whether the plan gets paid because this contract should govern your arrangement with the plan, and it's not your responsibility or your fault if the plan doesn't get paid by the state. It's the plan's fault. I understand that position. It will be very hard to persuade a plan that they should pay you even if they don't get paid by the state. I think it's very difficult to win on that ground. However, it really comes down to the New York State prompt payment law. If that requires the plan to pay you within a certain period of time, I don't believe the New York State prompt payment law makes any allowance for whether the plan is not getting paid by their purchaser, by the state or by an employer. Once the clock starts for any of those claims. I think from a contract or a legal perspective, one would argue that the state law trumps any provision in your contract to the contrary, and in probably an ideal world, this New York State law would govern and trump any disfavorable provision here in your contract, such as the one here. So I think this is worth fighting the plans on, but ultimately it might not be fatal because the New York State prompt pay law might supersede the meaning of this provision. Section 3.5 relates to penalties, specifically regulatory penalties. As I mentioned in prior webinars, plans are astute and have realized that if they get fined by the state, they want to pass those fines down to their providers when the provider might have had some influence on the plan getting fined. So, for example, if you closed enrollment or a practitioner left your facility and therefore a patient didn't have access to services, but the plan didn't know about it because you didn't tell the plan that a provider had left or that you had reached capacity and stopped accepting new patients, and the state came down on the plan because the patient had nowhere to go and fined the plan will then want to pass the penalty bit down to you for your failure to notify them that your panel had closed or the practitioner had left. But I think this is an awful provision because you basically have unlimited liability to the plan, and you can't challenge the plan's fine by the state because you don't have a relationship with the state in regard to that particular fine. So I do strongly encourage you to try to get this entire provision struck. Many of you took my advice and recommended that you should make the point to the plan that you should only be liable to the extent that you've agreed to indemnify the plan pursuant to the indemnification clause of the contract. I would encourage you to make that argument to the plan that you are already indemnifying the plan in the event that they get fined or have any claims brought against them for anything that you did wrong. You should rely on the indemnification provision in the contract and not this penalty provision. I've had smaller providers succeed in getting this provision removed, but that's because the plan needed them in the network more than the provider needed the plan, and they were able to use that leverage to get unfavorable provisions removed from their plan's contract. So it really does come back to knowing how much leverage you have with the plan and how much they need you to fulfill their network adequacy requirements. Oh, and then some of you realize that this provision allowed the plan to recoup any fines by offset. Obviously, that's not good at all, and you should certainly try to get that provision removed, even if the plan doesn't remove the rest of the regulatory penalty provision. It doesn't give you any right to object or to appeal, and you should try to get those rights in there as well if the plan doesn't agree or concede and allow you to remove the provision entirely. Section 4.1, the term of the contract. The first issue that came up was many of you wanted the initial term to be specific and clear in the contract. So, for example, a one-year initial term rather than just being this vague provision with the term lasting essentially until contract termination. The second issue that many of you pointed out was you did not want an automatic renewal clause. You didn't want an evergreen provision without having the ability to negotiate a new payment rate or without the automatic renewal being contingent on both you and the plan agreeing on new payment terms. Because as many of you know, you get stuck in a fee schedule, and if the contract is continually renews and renews and renews, you may not get any changes to that fee schedule for many years, which is not great as your costs continue to go up. Some of you specifically and thirdly said that instead of automatic renewal, there should be one-year increments. So it should renew for one-year increments each time. You know, this is something that you can negotiate with the plan based on your experience with that plan. Many of you pointed out that if you've never contracted with that plan before, it's desirable to have a shorter initial term so that you can identify any issues that come up in that course of that initial year, and then make sure you have an opportunity to renegotiate the terms of your contract to address those issues prior to the renewal of the contract. If you have a long-standing relationship with this plan, then maybe you trust them enough to have a longer term of the contract, maybe a 2-year or a 3-year period, but it's going to be based on your experience and your relationship with that plan. Section 4.2, related termination without cause. Some of you suggested that the 90-day notice provision or notice period was too long. Some of you wanted it to be shorter, like 30 days or 60 days. I would remind you that this provision works both ways. Either party has the right to terminate the agreement without cause upon that notice period. So if it's only a 30-day period, it means the plan can also terminate the agreement with you simply with 30 days notice. So you may want there to be 60 or 90 days so that you have a longer period of time in which the plan has to notify you before they can just terminate the contract for no good reason at all. Many of you, if not all of you, raised the question about what happens if you assume treatment after termination based on this language here that you have to continue providing covered services to members until the earlier completion of such services or assumption of treatment by another provider. Do you continue to get paid? This is an unusual provision here because in most provisions they say that if you have to continue providing services for continuity of care reasons, you would continue to get paid. The plan continues to have the obligation to pay you for those services. This provision does not say that, so you would want that language specifically added in. So even if you are providing services post-termination, the plan continues to have payment obligations. A few of you asked what would happen if it took an abnormally long period of time for another provider to assume treatment. Does that mean that you have to continue providing services? Yes, it does, and that might be something that's in the plan's control and not in your control. And so you have to consider whether you really do want to be stuck providing services to an enrollee where you've terminated the contract, because you may have terminated the contract because the plan payment rates were not sufficient or not adequate, and you wanted to not provide services anymore. Obviously, you have to continue. If you continue providing services at inadequate payment rates, that's a problem. So if that is you, maybe you want this provision modified so that that you can ensure the transfer of the patient to another provider, so that as long as you make the transfer to another qualified provider, you're now off the hook from providing services to that patient. Section 4.3 is termination for cause. I think it's important to point out here, many of you or some of you suggested that there should be a notice provision here of 30 or 60 days notice. Typically in most contracts with plans, there are certain conditions which entitle the plan to terminate immediately, like you lose your license as an organization on a provider facility level, or you end up going into bankruptcy. And then there are certain reasons for cause where the plan isn't entitled to immediate termination, but termination for, based upon 30 days notice. So something that is important or significant, but gives you notice and gives you time to correct the problem. This provision is unfavorable because it lumps everything together in a single provision where the plan has ability to terminate the contract immediately based on all these things, where some of these things should not be grounds for immediate termination. So, for example, subsection G, if you cannot or will not comply with any amendment to the agreement, that shouldn't be grounds to immediate termination. To me, that's something that should be maybe grounds to termination, but you have 30 days to fix the problem or to come into compliance with that requirement. Many of you picked up on the fact that this is completely a one-way provision. It only allows the plan to terminate for cause. It does not allow you to terminate for cause. So you should have this provision rewritten so that there are certain grounds which entitle you to immediately terminate the contract. For example, the plan goes into bankruptcy or the plan loses its insurance license, so that you're not continuing to be obligated to provide services to individuals where you know you're not going to get paid by the plan because they are bankrupt. Some of you pointed out that the plan could terminate simply upon the initiation of criminal proceedings, not conviction for criminal proceedings related to your practitioners. I think that's a fair point, that simply the initiation is not sufficient, and you should have that discussion with the plan, so that that's not grounds for termination, because that does seem unfair to me. Second, many of you also saw that if your practitioners were terminated or if they lost their license, then the plan would have the ability to terminate the entire contract. You see that in subsection I, where it references your practitioners, as well as you see it in subsection subsection where is it? I think it's in another section somewhere here where it references practitioner. Many of you heeded my advice that a single practitioner should not have sort of control of whether you have a contract with a plan or not. That's too much power. So if one of your providers or practitioners lose their license, it should not result in give grounds to the plans to terminate the entire contract, presuming you have other practitioners employed by your organization as well. Section 5.2, the indemnification language. First, many of you pointed out this should protect you as well as the plan. This provision is only written to protect the plan. It's one way. You should request that the provision is revised to apply to both parties so that each of you are indemnifying the other under certain circumstances. Some of you said, I don't know what this provision says. I don't know what this provision means. If that's the case, you should certainly ask the plan to explain it. Some of you said that you might need your legal counsel or your insurance broker to help advise you on this one because the language is very technical at the end regarding whether this just extends to negligence or whether it extends to willful misconduct or omissions. Some of you felt that it should not include negligence. It should only include willful conduct. However, I think that would be a very tough sell with the plan. Many of them are concerned about if you're sued for negligence, for malpractice, that they would be sued and they would have some liability, and so they do want this to extend to negligence, not just willful misconduct. I do think it's a good idea to check with your counsel or your insurance broker to see whether you have insurance coverage that would protect you in the event the plan sued you under this indemnification clause. Many insurance policies do cover contractual indemnification and would protect you. Many of your malpractice insurance policies would also cover indemnification in the event of malpractice and the plan gets sued and the plan sues you because there was some recovery made against them. And so you should make sure that your insurance coverages will cover and extend to indemnification liability. Section 5.6, the notices section. This was also a trick section in a way because it referred to the address identified on the signature page. If you actually take a look at the sample contract that I provided to you, the signature page is actually missing. I didn't see anybody pick up on that. Clearly, you would want to have a signature page in your actual contract, and if it did reference the addresses on that page, they need to be correct and accurate. But many of you made the very well-taken point that the notice provision should have more detail, and it should lay out specifically the name, title, and address of who receives notice, whether electronic delivery is allowed, or whether it has to be by mail. Many of you suggested that there should be more than one name in the notice provision just to have a little redundancy built in to make sure you did not miss any legal notices that were sent to you. Even if the plan just has one contact name, that doesn't mean you can't have two contact names. It may be your CEO, maybe it's also your CFO. Some plans throw in their legal counsel as a required party that has to be notified. But the most important thing is that you make sure that you don't miss an official notice from the plan that would, change or amend the contract. Speaking of amendments, 5.7 is the amendments clause. This is a terrible provision as a sample provision. Many of you said, what does the word material mean? Because this provision allows the plan to change anything that's not material without your consent. Some of you suggested that the term materially adverse change be defined. I would suggest that you just have that term deleted and that the plan have no ability to unilaterally amend your contract regardless of whether a change is material or not. If it's in the contract, my view is that it's material, it's important, and that you need to have the ability to approve any particular change that they propose to make. All across the board. Some of you suggested that you should have equal amendment rights, so that you should be able to propose amendments to the plan. I think that is a good suggestion, but it's not likely to prevail. I raised that point with a plan recently in contract negotiations and said, you know, why shouldn't the plan provider also have the ability to propose amendments to the plan? Also, there was an auto amendment clause in that provision in that contract, where if the other party didn't object, the amendment automatically went into effect. The plan said no. They said they wouldn't have the ability to handle if a whole bunch of providers started proposing amendments to their contracts. They could be overwhelmed. You know, if they have 200 or 300 providers suddenly suggesting amendments, it would be unwieldy. And so they rejected any ability for the auto amendment clause to be extended to the provider. That said, you should still have the ability to propose amendments even if they don't automatically go into effect if you don't hear from the plan. So both parties should have the right to propose amendments, not just the plan. Some of you said that this provision is okay and no change should be required at all. I would say no. You should definitely make sure that you have the right to approve any amendments from the plan. If the plan has a notice period where you have 30 days to object, and you object, the contract should not be terminated, or the plan should not automatically be able to force you to terminate the contract. Many of you picked up on the fact that this provision seems to require you to terminate the contract if you object to any of the plan's amendments. That's entirely unfair. If you've already agreed to the contract, the plan has already agreed to the contract, the plan shouldn't be able to force you to terminate simply because you don't agree to their proposed amendment. The contract should remain in effect, and many of you pointed that out. The next section, 5.10, is the disputes resolution clause. First issue here, many of you mentioned, is that you need a streamlined process for any claims disputes, separate from any contractual disputes about obligations. Second, many of you suggested that there should be a mediation option before moving to arbitration. And so many of you suggested that you remove the requirement to exhaust the internal appeals process by the plan. As I mentioned in prior webinars, if there is a requirement to exhaust appeals processes and the plan leaves you hanging on the last level of appeal and you don't hear back from the plan, then your rights to dispute the issue under arbitration or through this provision could be stymied. You might not be able to use these arbitration provisions or mediation provisions if you have not exhausted the plan's internal appeal process and they have control on whether you've exhausted it or not. So you should try to get that language changed as well. Some of you wanted to know what the internal appeals process was and make sure that you weren't left hanging there, that there were some time limits to the plan taking action and responding to your appeals. You need to go to the provider manual and see what it says there. However, as you know, the plan can change the provider manual whenever they want to, and so they can alter those terms. So while they're good to you now, they may not be good to you in the future, and so you may want to seek language in this actual Section 510 that doesn't require you to exhaust the internal plan's processes in order to invoke your right to arbitration. Some of you didn't like the time frames that were imposed in this provision, where you lost the right to arbitrate if you didn't bring a notice within 12 months. Some of you didn't like the 60-day requirement to resolve issues and felt that was unfair. You could raise that issue also with the plan. Next we move to the product addendum, and I've actually split this up into 3 slides to make it easier for you. This first sort of preamble, this first paragraph in the product addendum clause is the third and final all products clause that can be found in this contract. You can see the language here says that the plan may amend this product addendum by adding new products. That means that the plan can add new products at any time. That's an all products clause. this preamble also says the products available under this product addendum are listed below. Some of you picked up on the fact that the product addendum actually didn't list any specific products below. And so if there's a gap, and I do see this many times where the contract says, you know, something listed below or in the Exhibit A, and then there's no Exhibit A or nothing listed below, go back to the plan and say, I think there's a drafting error here, or I'm missing something, because something is suggested to come later and it's not there. In the first part of the product addendum, there's these 4 general provisions here regarding cooperation, treatment plan, delegation, and termination. Some of you raised questions about the second one in regard to treatment plans, saying that the plan shouldn't have this much control over your internal decisions regarding a patient's treatment, and was concerned that the plan was sort of encroaching upon your medical judgment. There was concern about wanting to make sure to maintain your autonomy in making those decisions. Here I think it's actually helpful probably to go to the plan's provider manual, which is referenced in this provision, and see really whether the plan is encroaching upon your medical decision-making ability, and if it is, then deal with it. But maybe the plan just is very broad language, and it doesn't actually invade your prerogative, your autonomy that much, but it's worth looking into. Number 3 relates to delegation. Some of you said the question, you know, what does this mean pursuant to a separate agreement? So a delegation agreement here for credentialing would mean that the plan delegates their credentialing obligations to you, the provider. But you have to typically ask for these delegated credentialing agreements. Plans don't automatically give those rights to providers. So if you are a provider that has the capacity to do credentialing, you have to ask for it. Perhaps you have to negotiate it with the plan so that they have to give that agreement to you. If that's the case, you'd want specific language in the contract. You might want language that says that plan agrees to delegate credentialing activities to provider, subject to the terms of the providers of the delegated credentialing agreement that provider and plan agree to execute following this agreement. That would guarantee you the right to have that delegated credentialing agreement. Termination. This is where it references the individual practitioners. I knew it appeared somewhere else. This gives the right for the plan to terminate a product addendum in the event that the plan takes action against one of your individual participating providers under Section B, as well as under Section C. They terminate the provider's participation under the product addendum. You don't really want that ability for the plan to terminate in the event that an individual practitioner loses their ability to participate in the plan's contract. Some of you also wanted the plan to have, also wanted you to have your rights to terminate. I think it's a little unusual to have this termination clause at all in the product addendum, and not have it actually just be based on the provision in the main contract, and so you may even want to suggest to the plan that this entire provision of termination, number 4, get struck, and just have it handled under the main contract. Lastly, some of you pointed out that while under Section 1 for cooperation, you have to cooperate with them, there's nothing that mandates the plan to cooperate with the provider, and that you wanted the provision to be mutual. Lots of additional comments about the termination clause related to the issues that we already covered in the termination provision under the contract. And I think the most important thing is that it's really confusing from a practical perspective when you start having this type of redundancy in the contract. You know, you have one termination agreement in the main contract, and then you have another one in the contract and the product addendum. That doesn't make any sense to me, to have individually specific termination clauses that are specific to each product addendum. It's much easier from a compliance and operational perspective to have a single termination clause that applies to all the plan's products, and just have one provision. Lastly, the compensation provision in the product addendum. Here, many of you picked up on the fact that it's the plan's fee schedule that you would be subject to, and that it is subject to modification at any time by the plan. In other words, they can change the rates that they pay you whenever they want under this agreement. Not a good, favorable provision for a provider. In my view, the fee schedule should be fixed. The plan should provide you the fee schedule. It should be an exhibit in the contract, as many of the plans do provide, and that should not be subject to change by the plan. Some of you raised the question about New York State's fee schedule. Yes, because you are guaranteed rates under Medicaid for the first couple of years in this transition, certainly a product addendum that applies to Medicaid patients should reference the Medicaid fee schedule or the APGs or whatever the special rate is that you're guaranteed under the Medicaid for Medicaid enrollees, and not just the plan's internal fee schedule or their commercial fee schedule, because you have special rates that you're guaranteed in the transition. And then lastly, some of you picked up, which is very good, on the fact that the third sentence of this provision says that in the event that self-funded products are offered, payment for covered services are the responsibility of the employer or other payer, not the plan. What does that mean? Some plans do contract with typically large employers who are self-funded. That is, they don't contract with the insurance company to insure their employees. They simply contract with the insurance company as a TPA, as an administrative body to administer their plan, but they pay the employer pays all the claims. Here the plan is saying if they're in a self-funded situation, they're not liable for payment, the employer is. I think many of you realize that that's not a good situation because you don't have any contractual relationship with the employer. If the plan doesn't pay you for a self-funded patient, you can't sue the employer. You don't have a contractual relationship with the employer. And so it'd be desirable to get this provision removed, this sentence removed, so that the plan is always liable to you for any of the contracts that they hold, regardless of whether it's a contract with an employer, workers' comp with the state, or with the federal government with CMS. The plan is always liable to you for payment for services. All right, I think we reached the end here, and we have about 15 minutes left for any questions.
Great. Thank you so much, Adam. So we've been collecting some of the questions that have been coming through both mctac.info@nyu.edu. Thanks to folks for sending those in advance, as well as things that have been coming through the webinar. So if you're not familiar with the Q&A format, on the right-hand side of the WebEx screen, there's a little, depending at the top or bottom, depending what kind of computer you're using, a little chat icon with a little word bubble. So you can chat that in and send to all panelists. We'd really appreciate it. So again, thanks again to Adam for a fantastic presentation and taking the time to go through what was a remarkable number of submissions of the assignment. That was incredible feedback and really helpful context and nuance around some of the areas that folks were finding to be problematic. So it sounds like the participants did pretty well in working through the assignment. So just off the top, we've received a few questions so far. So let's just dive in. So one question is, do you know, Adam, is New York a state that allows plans to retain their capitation payments?
No, it's not. So it's not one of the states that allows a plan to retain the capitation payments when they've already used part of it to pay a provider, which is unfortunate. So that means that you don't have a very good argument to the plan that you should continue to receive or keep the claims or the money from any retroactively disenrolled individual.
Great. And then another question that came through is asking if it's advisable to ask the respective plans if an agency's contract attorney can speak directly with one of their contract attorneys in order to negotiate changes. I don't think there's any problem with asking the plan that you have an attorney that you want to speak to with the plan's attorney.
you may get some pushback. Maybe the contract rep may say, oh, that's going to draw out the process, and that's going to mean that you don't get a contract as a participating provider because it has to run through our legal department, and that's going to extend the process, and you won't be in our network as soon. They may give you some pushback there because it means more work on their end, but that may be worth it for you. Your reaction to that might be, that's okay, because I don't want a bad contract, or I don't want to be contracted under rates that don't pay me adequately. But I do find that typically the plan will want to talk attorney to attorney, or if you want to involve your attorney, then the plan's going to want to involve their attorney, and vice versa.
Great. Another question came through, actually, speaking of working with the plans. So it sounds like one of the workshop participants had a lengthy, maybe 7-month negotiation process with a plan on a contract, and their experience working mostly through a provider relations rep who seemed to not understand or was resistant to most, if not all, of the suggested changes, with many just being refused outright. And I'm synthesizing, so if I need to repeat anything, just let me know, Adam. And then so they worked exclusively through the provider relations rep and didn't really speak to anyone else. So is this typical for a process of contracting with an MCO? And if so, just going directly through a provider relations rep, do you have any suggestions at the practical level about how to go about the contract negotiation process with that level of staff?
I would say it's unusual. It's an unusual reaction for a plan that's participating in public programs. If this is a plan that has one of the Medicaid MCOs, then I would find it surprising that the provider relations rep was so resistant or didn't understand the proposed changes. If it was just a commercial product or a commercial plan where providers have, I think, fewer rights, then it's maybe less surprising. If you're not getting anywhere with the provider relations rep, and many of them, by the way, are new in their position. There's a lot of turnover in these positions. They may not actually understand what your suggestions are. Maybe you want to ask them to speak to their manager, or maybe you want to say that if you have an attorney or access to an attorney, that your attorney is going to get wants to speak with the provider relations person. Maybe that will prompt them to get their own attorney involved so that you can move on to somebody else to try to work some changes through. If you find that these provisions you're not getting anywhere at all with this particular plan, then maybe you want to think twice about whether you can really contract with them. But you really need to know whether you have any ability and any leverage to say no, or in the sense that you need to know how much the plan needs you. If they are not making any changes to you, maybe you have very, very little leverage, and you ought to do some hard thinking about how you might increase your leverage in the future, either by joining a network or an IPA or some other system where a larger group of providers is negotiating with a plan, or somehow demonstrating to the plan that you provide superior services than maybe another provider and will cost them less for the total cost of care, some other either or market-based solution to try to improve your contracting leverage.
Great, thanks for that answer. Another question that came through about a request for plans. Is it advisable, which I know is a subjective word, is it advisable to request plans to include stipulations in contracts that they will be bound by provisions for provider protections, promoting service access, promulgated by the New York State Department of Health, or something to that effect? Rather than argue for every specific and oftentimes evolving policy provisions that are required by the state to be specified?
Well, you may have some of that language already in the contract. As I mentioned before, there's usually a section in the contract that applies that relates to your obligations as a provider, and then there's typically another section in the contract that relates to the plan's obligations, and sometimes those provisions for the plan's obligations do say explicitly that the plan is required to comply with, federal law and agrees to comply with state law and other policies that are issued by the state. And this is where you may want to maybe add language to make it more specific to include New York State's, DOH or OMH or OESAS, so that it is specific to those policies that are issued. And it might not be such a big ask because you'll have language that starts to go there. I don't think a plan would say no to that, though they may want to limit those requirements again to their Medicaid product and have that language specifically in the Medicaid product addendum that they have so that it doesn't apply across the board to all their commercial and Medicare products.
Great. And on a similar note, so New York State has said that no prior authorization is required for ambulatory services, and that plans cannot include all products clauses in their contracts with OASAS and OMH providers. So like a very basic question around that. So does that mean that MCOs may not include these provisions in their contracts? And if a contract comes through that has one of those provisions, what is a provider's best option or recourse?
Yes, I'm very encouraged by the fact that that Medicaid update said that. I'm very encouraged by other statements by OMH that says that all products clauses won't be allowable, and until the plan's contract with the state is modified under their model contract, I think all you can do is rely on these statements by OMH, OASAS in this Medicaid update or the other PowerPoint presentations that they've had saying that they won't allow an all products clause, and that's all you can fight the plans with if you see these all products clauses provisions in their plan. Ultimately, if it does get into their model contract, then there'll be a specific prohibition by law that relates to them. You have to realize these Medicaid updates are not law. The Medicaid updates are stating the department's policy, what their view is, but it does not bind the plan anymore. That these updates don't really bind you either. This is not law or regulation that's issued under, your legal notice and comment period. These are just statements of policy that are issued by the state agencies. They're not contractual requirements.
Great. And then another question that came through, well, two logistical questions actually, so we can give Adam a quick breather as we kind of approach the home stretch of the Q&A and the workshop series. So a question came through about is there a way that we can capture some of these suggestions and feedback on the contracting exercise in a document or on the contract itself. So we'll touch base with Adam following this to figure out the best way to disseminate some of the information and recommendations around the areas that were found problematic. Again, just to reiterate off the top, we discussed at the very beginning of the webinar that we'll be working with Adam to put together some general fact sheets and information about contracting that cover much of what was captured in this exercise and the provisions. So stay tuned for those as well, and we'll follow up with workshop participants with some additional resource suggestions in the coming week or two.
Dan, I would just say that I think that's a great suggestion. Like maybe we can create some sort of answer key essentially that aggregates all the information that we receive from all the participants in the program, so they can use it to make their own checklist to make sure they caught all the issues in the contract.
Yeah, fantastic. Couldn't agree more. And then another thing about something that I know already exists. So the question is, are we aware of plans that have specific contracting departments? So for that, yes, we are. But instead of listing them out, we'd strongly suggest folks go to the MCTAC's Managed Care Plan Matrix, which is available at MCTAC.org, or you can go directly there at Matrix, like the movie, .mctac.org, and it's an interactive tool where you can, either by searching by plan or clicking on the respective county that you're in. Granted, just to be clear, this is only available for New York City at this point because that's where plans have been identified and contracted with. So we'd strongly suggest folks to look through the plans that we have listed there, and then there are tabs for each plan, including general information, contact, which will oftentimes have a contracting person listed, as well as specific contracting information, including their standard termination clauses, and their specific contracting departments or people that you can reach out to specifically. And we worked in partnership with the managed care organizations to pull this all together. So in the event that any of them are on this call and participating, you know, we really appreciate that, and we think that this is going to be a great resource for folks. So as opposed to every single agency or provider having to pull this information together individually and keep track of it, on a quarterly basis we'll be updating this, and so you know all providers can have a pretty streamlined sense of the information that you need and who to contact at the respective plans to have various questions answered. We had a question, Adam, about section 5.9. And it seemed to be just a comment, but if you wouldn't mind just kind of going back and addressing 5.9, we're talking about where a plan's primary office is located, not where provider's office is located.
Okay, yes. So 5.9 says that this agreement shall be governed in all respects by the laws of the state where the plan's primary office is located. In the event of a lawsuit, venue shall be proper only in the county where the plan's primary office is located. So this actually has two separate statements. One relates to whose law governs any disputes, and here it says that the laws of the state where the plan's primary office is located. What does that mean in the sense that I know, you know, plans are insured and licensed under state law, so there's always typically an office within the state, but if a plan is headquartered in another state like Minnesota, does this suggest that the laws of Minnesota would govern the contract? I don't think you'd want that as a New York State provider. And so you might want to have this provision altered in that first sentence so that it specifically says that it's governed by the laws of New York State. Second, it says in the event of a lawsuit, venue is only proper in the county where the plan's primary office is located. The problem with these venue clauses is that if the county doesn't have federal court, for example, then you are almost writing your way out of your right to go to federal court. Or at least you'd have to fight the plan or the other party on that you did not knowingly waive your right to go to federal court by agreeing to this provision. So I'm always dubious of these county limitations. I like it, but if you do have them in your contracts, make sure that if a specific county is located, that you have both state and federal courthouses in that county. In the event that there was any dispute, you would have rights to go to both state and federal court.
Great. So another question that came through was going back to the all products clause, and so let me just put it up.
Which one?
So right. This question might be one that I can answer, and then Adam, if you just wanted to provide any other clarification on how this is looked in other states, perhaps. But so, why is it that the all products clause protection is only for OMH and OASAS providers and not for OCFS providers as well? And my take on that, to be honest, is just this is specifically around the adult system transition to Medicaid managed care, which is happening imminently. The children's system, which includes OCFS agencies, will be January 1, 2017 in New York City and Long Island, and then a little bit later for the rest of state. So my understanding of this is just that this decision was made and this protection put in, not to be exclusive of the KID system or anything, but just with just from a time frame standpoint, to address specifically something that's the OMH and OASAS agencies that are currently contracting with Medicaid managed care, and also mostly in New York City. Does that sound right, Adam, or is that your take as well on this?
I guess it would a little bit depend on what the Medicaid update said and what is going to be in that final model contract. I would think that any provider, whether it's for adult or children, when those services are ultimately, or if you're contracting with a plan and they're paid for by Medicaid, then I think this all products prohibition should apply. But until you are paid for those children's services by the plan, which I know comes later, then you don't have that protection. So it's really contingent, I think, when you as a provider starts receiving payment from a plan for the services for those Medicaid children.
Gotcha. Thanks. So hopefully that helps. But again, just as more the state RFPs, RFQs aren't yet out for the kids and the MCOs. They are out for the adults. So just the timeline is a little bit different on that end. And then speaking of timelines, I think the last question we got today as we wrap up, just on the logistics end, is when do we anticipate the matrix to be updated for the rest of New York State? So with any luck, it'll be a bit of a quicker turnaround, with a little bit more advanced than for New York City. We went live in early July with a go-live date for Medicaid managed care in New York City, October 1. So we'd look to have information up there as soon as possible, and we'll work with the plans in the background as they have a solid idea of the information and the right people to contact and the various information, and as they're responding to the state RFQ, to include all this information in a timely manner, so it's as helpful as possible to providers. And then one last question, if you've got time for it, Adam.
Sure.
So speaking of upstate, we had one final question in terms of time frame. So for folks who are upstate, what's a good time frame, or when should they be approaching managed care companies? And will companies be contacting them if they have over 5 clients, or should they be reaching out in advance?
I think that it's never wrong to contact the plan. I think it's bad to be in a passive position where you're waiting for the plan to contact you. If you want to go after a contract, then you should reach out to the plan directly. They'll tell you whether they're ready to contract with you as a provider or not, but no reason to sit on the sidelines. I sort of think first in have an advantage, and so just to go do it.
Terrific. Well, with that, we're a little over past 11, so thank you so much, Adam, and to all of our participants for joining us. This wraps up and concludes our contracting workshop series for the summer. But as we mentioned, we'll be continuing to work with Adam on a few additional resources, so please stay tuned for that. And also just a final reminder that a recording of today, as well as the slides from the presentation, will be made available at the MCTAC.org website. So thanks again to everyone, and look forward to seeing you all again at future offerings. And thanks again to Adam so much for all of his work pulling this workshop series together. It's been fantastic.
And thanks to MCTAC and everybody for participating today.